Amendment 5. Grand jury, double jeopardy, self-indiscrimination, due process, takings, passed by Congress September 25th, 1789, ratified December 15th, 1791. The first 10 amendments form the Bill of Rights. No person shall be held to answer for the capital or otherwise infamous crime, unless on the presentment or indictment for a grand jury, except in cases arising in the land or naval forces, in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy for life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Common interpretation. The clauses of the Fifth Amendment The Fifth Amendment Criminal Procedure Clauses by Paul Cancel and Kit Stith. 3 of the 5 clauses of the Fifth Amendment pertain to procedures that must or must not be used in criminal prosecutions. Grand jury indictment. The first of the criminal procedure clauses requires that the felony offenses in federal court be charged with grand jury indictment. The grand jury is a panel of citizens and hears evidence that the prosecutor has against the accused and decides if an indictment or formal criminal charges should be filed against them. This is one of the only a few provisions of Bill of Rights that the Supreme Court has not held to apply to states through the Due Process Clause of the 14th Amendment, the others being the Third Amendment's protection against quartering soldiers, the Sixth Amendment's requirement of trial in the district where the crime was committed, and the Seventh Amendment's requirement of a jury trial in certain civil cases, and possibly the Eighth Amendment's prohibition of excessive fines. And the court has been reluctant to apply the grand jury requirement to the states is unsurprising. While the origins of the grand jury, an ancient ancestor of the modern grand jury, was including the Magna Carta. Today, the United States is the only country in the world that uses grand juries. In addition to the federal government, about half the state provide for grand juries. So in many of these, there exist other ways of filing formal charges, such as prosecutory information followed by adversarial, but a relatively informal preliminary hearing before a judge to make sure there is at least a probable cause for the charge, the same standard of proof that a grand jury is told to apply. As early as 1884, the Supreme Court held that the grand jury is not a fundamental requirement for due process, and Justice Holmes' long dissent from that judgment has been joined by only one Justice, Douglas, in the intervening years. Recent scholarship has upset the previous understanding that the grand jury was from its inception venerated because it was not only a sword accusing individuals of crimes, but also a shield against oppressive or arbitrary authority. In its early incarnation in England, the grand jury was fundamentally instrumental for the crown, obliging unpaid citizens to help enforce the king's law. Over the centuries, the idea of a citizen check on royal prerogative became more valued. By the time of the framing of our Constitution, both grand jury from the French and for large in size today grand juries are often composed of 24 citizens, and the petit jury from the French for small today criminal trial juries may be composed of as few as 6 citizens, were understood in both Britain and the colonies to be important bulwarks of freedom from tyranny. Few in the modern era will expose such a view. The former Chief Judge of New York Court of Appeals, the state's highest court, famously remarked in recent years that because prosecutors, agents of the executive branch control what the information a grand jury hears, any grand jury today would, if requested, indict a ham sandwich. While this is a useful exaggeration, the Supreme Court has held that the federal grand juries need not adhere to trial rules for evidence or to be told of evidence as culpating the defendant. A few prosecutors, fortunately, are interested in indicting ham sandwiches. Rather, the greatest advantage grand juries now provide, at least in federal courts, was not as overburdened as the state courts, is allowing the prosecutors use the grand jury as a pre-trial focus group, learning which evidence or witnesses are especially convincing or unconvincing. At least in federal court, grand juries are here to stay. The institution is written into the Fifth Amendment. Too clear to be interpreted away. Moreover, neither pro-law enforcement forces, for obvious reasons, nor allies accused, because occasionally grand juries do refuse to indict in the legal parlance, returning to no true bill, have reason to urge the abolition through amendment of the Constitution. Double jeopardy protections. The Fifth Amendment's second procedural protection is a double jeopardy clause, which provides, nor shall any person be subject for the same offense to be twice put in jeopardy for life or limb. The clause's core purpose is straightforward: to prohibit the government from forcing a person to undergo repeated trials for the same crime. As Justice Blank explained in the oft-quoted passage in Green versus United States, 1957, the underlying idea is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. While the double jeopardy clause's underlying principle is straightforward, the clause has spawned complex jurisprudence. The current rule set forth in cases such as Christ versus Bretz, 1978, is that jeopardy begins or attaches in a jury trial when the jury is expelled and sworn. Much of the double jeopardy jurisprudence addresses circumstances in which prosecution is neither permitted or barred after jeopardy has attached. One common situation where this question arises is when the government seeks a retrial for a mistrial, a trial terminated before a final judgment is reached. If the defendant consents to the mistrial, retrial is permitted. But the early Supreme Court case, United States versus Perez, 1824, established that even without consent, the defendant may be retried as long as declaring a mistrial was a manifest necessity. In Perez, manifest necessity was a hung jury, a jury that could not agree upon a verdict. While the term necessity might imply a nearly impossible burden for a retrial, the Supreme Court has been fairly generous in recognizing such circumstances. On the other hand, retrial is not permitted after acquittal, a finding that the defendant is not guilty. Although it has not addressed the rare situation where a jury has been bribed, the Supreme Court has made it clear that the double jeopardy clause flatly bars prosecution for the same offense.